Hey everyone, Nathan here, president of Saybrook University. Welcome to another episode of Saybrook Insights. I have the pleasure of speaking with one of my esteemed TCS education system colleagues, Dr. Jackie Gardina, Dean for the Colleges of Law located in Santa Barbara and Ventura, California. As one of the premier schools in our system, the Colleges of Law has been educating attorneys for several decades, doing amazing work across the landscape. And what better time than now, given the various decisions coming down from the Supreme Court and everything that's happening in California and beyond, than really to speak with a formidable force in legal education in Dean Gardina. Like many of you, I have been awash in emotions and yes, confusion by some of the recent decisions that have come down from SCOTUS or the Supreme Court, whether it's Roe v. Wade or the recent gun control decision or the separation of church and state or the EPA decision for that matter. Future SCOTUS sessions will likely prove even more vexing no matter what ideology one adheres to in their personal life. And that brings me to the idea of unintended consequences as it relates to our laws and the decisions that get made about their constitutionality. Along with that, we have what I and others likely could be labeled as the weekend warrior complex. We have these vague understandings of the laws themselves, along with their implications, but often opine like we really know what we're talking about. Now, I do read the decisions when I can, and if it's a proposed bill of interest or something like that, I'll review it, time permitting. But I suspect, like many of you, there are so many hours in the day that we can dedicate to such in-depth reviews of those types of documents. Enter in Dr. Jackie Gardina, who I'm hopeful can shed some light on the pressing legal issues of our time, help us figure out how to make sense of all this change and offer insights into legal education and the profession as a vehicle for positive social change. This certainly isn't your grandma's Perry Mason. In fact, it's a lot better than any of those episodes could ever be. And I think you're going to find this episode truly engaging, motivating, inspirational, all the superlatives you can think of. She's powerful, and I think she lends important analysis not only on SCOTUS, but on legal education, where we're headed, what we're going to be able to do going into the future. So let's get to it with Dr. Jackie Gardina, Dean for the Colleges of Law at TCS Education System. Dr. Jackie Gardina. It is truly an honor to have you here on Saybrook Insights. Before we get started, maybe tell us about yourself, your personal history as it relates to your work as an attorney, a legal educator, and how you found your way to the vaunted deanship at the Colleges of Law.
Well, first of all, thank you so much for inviting me on to Saybrook's Insights. I am excited to be here. It's hard for me not to start with my childhood because I think my childhood is directly linked to my decision to become a lawyer and the path that I took. I come from a very large family. I'm number 9 of 10. And so we had as you can imagine in that environment, fairness and equality was a primary concern, especially for someone on the younger end. So I was sure to always be advocating to make sure that the cake was sliced appropriately, that the sufficient food was available to even those on the younger end. So I've always been supportive of the underdog in that respect. But I think I also was someone who was contrarian, and so I was told at a very young age, you should become an attorney. I can remember conversations I had with my parents where I think, gosh, what a challenging kid I must have been. But I finished up my undergrad degree at University of Iowa, and I really started to question whether or not I wanted to go to law school or whether it's just that everyone had said I should go to law school. So I actually hit pause on that, got involved in the human services field, and started working with kids and families. And I'm someone who really likes to have a lot of tools in my toolbox. So I decided to get a master's in social work. And I ended up getting a master's in social work and then working for about 6 years in that field before I actually ultimately decided to go to law school. And what prompted me to finally make that move was, I think, two things. One, I was in the courtroom testifying as an expert witness in termination of parental rights, in visitation cases, as well as some criminal cases as an expert witness. And the other piece was my ability in the state I was working at. I was working with adult survivors of childhood sexual abuse as well as kids. And we advocated with the Senate Judiciary Committee in that state to change the statute of limitations to allow those victims of childhood sexual abuse to actually sue their perpetrators after the age of majority. So we extended the statute of limitations. That just got me excited about having more tools in my toolbox to help people, which is what prompted me to go to law school. And then, as life would have it, while I was there, doors opened that I didn't even know existed, and I walked through those doors, and other doors opened, and then I ended up in Ventura and Santa Barbara, California, at the colleges of law.
I mean, that's like 5 lifetimes right there, Jackie.
Yeah.
And what she is not telling you is, in the heat of her job as a dean and all the other fabulous work she does, she also teaches. You did a PhD in higher education, correct?
I did an EDD. Yeah, at university. I have it will be conferred on August 5th. So we are actually recording this before its official conferral. But on August 5th, it will be conferred, and it's an EDD in education from the University of Pennsylvania.
Well, the heartiest congratulations from me and our colleagues here at Saybrook University on that. It was hard earned. So she's a doctor, a JD, and an MSW. And I really appreciate your insight on the journey that you took, especially taking a pause going into the legal profession and getting that social work background. Seems like it was massively helpful for you in sort of situating yourself in the law. When you got into legal work, what was your intention in terms of, focus of practice? I mean, you probably had some thoughts about, hey, I want to go do this and really make an impact here. What was that for you?
Yeah, so because I'd been working with kids and families and had been so frustrated with the system, I really felt like I was bandaging kids up and sending them back into a system that was incredibly broken. And I was also incredibly frustrated with the healthcare system, to have an insurance company tell me that I had 6 sessions in which to gain the trust of and help a young person who's been subject to some of the worst violations that one can imagine, was challenging. So it was my hope to really use my tools to create systemic change. The great thing about my social work degree is I went to a school that looked not just at the clinical side, but also had a community organizing bent to it as well. And so we looked not just at the individual, but at the systemic changes that we could bring as social workers. Adding a law degree onto that seemed like even more kind of tools in the toolbox to create the kind of systemic change that I wanted to see. But when I got into law school, certainly it was still on my mind, but my brain got ignited by things that I didn't think that it would. I ended up having opportunities emerge that were new and different for me, and I ended up taking advantage of them, which led to my interest in teaching. So I was able to clerk with a federal district court judge in Massachusetts right out of law school, and he had a courtroom full of 9-year-olds that were there for a tour. And he was explaining what lawyers do. And he said, lawyers are teachers. That's what we do. We teach clients, we teach judges, we teach legislators. And I thought, wow, what a wonderful way to practice law. And so I started adjunct teaching in Boston while I was still working as an attorney. And then I ended up getting a full-time job as an attorney, or excuse me, as a professor at Vermont Law School, where I taught for about 13 years.
And then you made your way out here west in that regard, right?
I did.
And in Vermont College, the Vermont College in which you were practicing, correct me if I'm wrong, they had a focus in environmental. I mean, it wasn't the only focus, but
Correct. It was the number one environmental law school in the country while I was there. So very committed to that. And that's how it started in the 1970s.
interesting. Okay, okay. I want to take us down the path of legal education since we're already here, and then I've got some major questions for you to help me puzzle through because I'm struggling, almost Dr. Gardina. I think we'll call you Doctor for the rest of this episode if that's okay.
Fair enough.
All right. So the colleges of law in Santa Barbara and Ventura, maybe explain to us what it is. Like it was founded, it's got a terrific history, and I think hearing from you sort of its, focus, its background in history would be helpful, and also its impact on the community. Would love to hear that from you.
So one of the things that attracted me to the Colleges of Law was its mission and was its history. So Colleges of Law was founded, the Ventura campus in 1969 and the Santa Barbara campus in 1972. And it was in the 80s when they joined together as one institution. It is what's called a California accredited law school. So it's accredited by the State Bar of California. And that's opposed to the American Bar Association, and we can certainly go down those distinctions if you'd like. But it was created by local attorneys to really create a pathway into the legal profession for individuals who couldn't pick up their lives and move to LA or move to San Francisco to go to law school full time. So working adults with families who are rooted in the community and who really wanted to continue to live and give back to the community. So it was a way to create a pipeline into the Ventura and Santa Barbara communities. And what's really fascinating to me when you look back at the photos of all the graduating classes, you can really see in the 70s and 80s that it was a springboard for women to enter the legal profession. And now you see some of those women in leadership positions. The DA of Santa Barbara is a graduate of Colleges of Law. Colleen Toy White created the mental health court, the veterans court, and the drug court in Ventura, and has a courtroom named after her. And we just have an amazing number of women leaders in the local community that come from Colleges of Law. What we're seeing now is really, it's a place for first generation and immigrant families to be able to come and get a legal education. So our school demographics represent the demographics of California. We're about 40% Latino and a mix across the board. Otherwise, we actually have a much higher percentage of people who identify as Black than the state of California does. And so we are really, I think, serving as a pipeline to diversify the legal profession. And if you just see the reaction to the new Supreme Court Justice, Justice Jackson, and what it means for someone to see someone who looks like them in that kind of position, it's powerful for kids to see people who look like them. And it also helps us have more trust in the justice system because it is representative and reflects the diversity of the nation as a whole. So Colleges of Law is really dedicated to that, and it's the reason why I picked up from Vermont and moved out to the Colleges of Law to be a part of that mission.
And boy, are we glad you did. I mean, that's just awesome. Yeah, full disclosure, Jackie and I have had the privilege of working together. Well, I've had the privilege of working with Jackie kind of at arm's length, I know, because we work far apart, but kind of have these opportunities to interact and engage in international experiences. And every time I'm buoyed by your energy and your intellect and what you bring to the table. It's just so wonderful to work alongside you when we get a chance to do that. I am just really impressed because the colleges of law, its founding is situated in this really progressive approach to higher education. And yes, there was a lot of progressivism happening in the 60s, but I don't usually think of it, and no offense to the legal profession, but I don't really count attorneys in that mindset of being very progressive, especially in that era. But the founders were really forward thinking, it sounds like, in terms of what they set up. Can you speak a little bit more about that? Because I don't think that was an instinctual sense for many across the country in the establishment of law schools. So I'd be curious your thoughts on that.
Yeah, and just to put it in a particular context, it was at the turn of the 20th century when the dean of Harvard Law School created what is basically now our understanding of legal education. So when we say that legal education and the law generally is backwards looking and steeped in history, it is very challenging for lawyers to move forward or think outside the box just based on our training. So they did two things that I think were unique. One is they created a part-time program that was specifically focused on working adults. And they were really committed to creating a pipeline into their communities and connecting the learning to the community. The second thing they did is they didn't seek American Bar Association accreditation, which comes with costs. It also comes with prestige, but it comes with cost. And instead, they sought something called the California Accredited Law School basis. So it means that the graduates of our school are only eligible to sit for the California bar upon graduation, although they are eligible to sit for other bars later. But it meant that they were committing to their communities and they were committing to California in particular by making those two choices. So the part-time was actually outside the box at the time that it was actually created and not thought highly of when we think of prestige. And so our students benefit, our current students benefit from the fact that 2,500 of our graduates have gone out into the community and done good work and kind of set the stage for them to graduate and be able to contribute their own good work into the community.
That's interesting. So let's rest in that Cal Bar ABA space because I know that's probably a sticking point for a lot of folks thinking about law school. And make no mistake, I'm a big fan of the colleges of law here. So if you're thinking about a legal education, you should really think about COL in Santa Barbara Ventura. So, you know, Cal Bar, you beautifully explained that, and the ABA piece. Maybe go into a little bit about the distinctions there. So with the ABA, what comes with that? And, there's always a cost benefit. So curious on your thoughts related to that.
Yeah, and I can talk a little bit about through the lens of my experience and what prompted me to make the move when I did.
Okay.
So, American Bar Association is a not-for-profit organization that the Department of Education has delegated authority to accredit law schools. It is expensive to be an ABA accredited law school. There's a lot of inputs. You have to have a particular size library. You have to have a particular size endowment. They look for a certain ratio of full-time faculty, whereas colleges of law relies heavily on practicing attorneys and judges. The other thing it does, and this is the part that was uncomfortable for me, is that it is really about hierarchy and it is really about kind of climbing a prestige ladder. So, for example, ABA schools right now, although this is shifting, are required to use the LSAT as an entry exam. We know that the U.S. News and World Report rankings will look at your median LSAT score. So one easy way to go up in the rankings is simply to clop off that bottom quarter of your LSAT, and suddenly your median LSAT goes higher, and you can go up in the rankings 10, 15 places in 1 year. But what does that do? It eliminates those individuals who struggle more on standardized tests, such as the LSAT. So you're going to lose more people from socioeconomic backgrounds that are at the lower end of the spectrum, and more likely than not, more people of color. So the other thing is that because of those inputs that are required and because of the costs, the tuition are incredibly high. We would have students leaving Vermont Law School with 150 to 200K in debt. And that's just their law school debt because you have to take 3 years off of work, you get living expenses, you pay for tuition, and everything else that goes with it. What was happening is, going back to the LSAT and the rankings, is they were using merit scholarships to pay for higher LSAT scores. So there were some people on the high end of the range that were getting full rides, and those at the lower end of the range were paying full freight for their tuition, and they were subsidizing those at the higher end of the range. So just ethically and morally, it felt corrupt, what was happening. And it is not an unknown in the ABA world that this is how the prestige and hierarchy works. And so when I talk to students about the difference between the two, I say there are fantastic reasons to go to an ABA law school. One, you have immediate geographic mobility. If you don't want to stay in California, you can go take the bar anywhere you want immediately upon graduation. The other piece that you're going to get is you're going to have access to full-time, full immersion law school. It's not a part-time school, although some of them have part-time programs. And you're going to be able to immerse yourself completely in law school, which I had the luxury of doing, and I do think it's a luxury. And you're going to have access to full-time faculty, and that could make a big difference for you.
Yes, it could make a big difference, but in relation to that full-time faculty versus the part-time faculty or practicing faculty, you've got judges and lawyers, at colleges of law that are just immensely gifted, who are just giving of their time and talents to these students, right?
Absolutely. And I tell them the minute you step into our classroom, you step into the profession, because the person standing at the front of that classroom, it could be your colleague in 3 years, it could be your boss in 3 years, it could be your opposing attorney in 3 years, or it could be the judge that you're going to be standing in front of. The people that are sitting alongside of you in that classroom are going to be your fellow colleagues in 3.5 years. You are already in the profession the moment that you enter our classroom. And you're right, the attorneys and judges who step out of their office or off the bench to come to our classrooms in the evening. And I should say, we also have a hybrid JD that serves students from across California as well as outside of California. But we have the same adjunct faculty basis there as well, and they have the same ability to connect with practicing attorneys and judges within California and also outside of California.
Okay, that's very helpful. So, last question on this, and then maybe a real quick one on degree programs, and then we'll get into my other query. So, when we look at the colleges of law framework and how that's all situated right now with CalBar, student graduates from the program with a JD, whether that's hybrid or your typical on ground. You noted that they can actually practice elsewhere, sit for the bar elsewhere, but it sounds like there's a waiting period. So let's say I'm from the state of Ohio, which is my home state, and I came to colleges of law to take my JD. How long would I have to wait to then go back to Ohio to sit for the bar there, or is that even possible?
It depends on the state of Ohio. So every state has a different set of requirements for sitting for the bar. Some states you're going to be able to waive right in. Other states you're going to have to wait 5 years. Other states it might be a year. Other states may say never. So it will depend, which is a standard attorney answer to just about any question.
I was going to say it's like you were trained in this profession or something.
And I also want to point out, and one of the things we've really been talking about a lot is the power of the JD, quite apart from a license to practice. There is an amazing number of opportunities that exist for people with a JD that does not require a license to practice law. And one of the things it does, especially for some of our graduates, is give them a seat at the table. A JD behind their name carries some heft. The training in thinking and writing and public speaking that we provide gives them the ability to, I think, participate in their communities in ways that they may not have felt confident doing before. And so we always try to talk about the power of the JD with or without a license.
So I am very interested in pursuing that hybrid JD at some point, Dr. Gardina.
We welcome you, Dr. Long.
It's a lot of work. I know that, but it's well worth it. So last question on colleges of law curriculum. The colleges of law, you have a few degree programs. Can you just provide those options for our students out there, prospective students?
So as we mentioned, we have campus JD programs that are on in Ventura and in Santa Barbara, and those are evening programs. We also have a hybrid JD that's blended. 70% of it is asynchronous and online, and then once a month they come to campus for an intensive weekend residency. And we created that it launched in 2018 was our first class. So we just graduated our first class of hybrid JD students. And it was really about, again, increasing access and opportunity for students who otherwise wouldn't have access to legal education. There's a lot of rural areas in California that lack access to a traditional campus program. So we've been really pleased that we've been able to expand our mission to a wider range of people. We also just launched a Master's of Arts in Law with a focus on business, entrepreneurship, law, and technology. It really is addressing the emerging jobs in the new legal industry. Law is really sitting at the intersection of business, entrepreneurship, and technology. And so giving students the ability to pursue certificates in, let's say, business operations and technology or entrepreneurship and emerging law, and they can really build a career path that meets their needs. And in addition, we're building a lifelong learning program so that those in the legal profession who are interested in kind of coming back and gaining some new knowledge and skills can take a course or an entire certificate in our lifelong learning program.
Some amazing options there, and it is feasible. I mean, I think you have professionals who are working full-time doing the JD program, the hybrid JD. Is that fair to say?
All of our students are full-time working adults. The average age in the hybrid JD is 42, and the average age in the campus is 37.
Okay, so it can be done and is done. I believe you've graduated at least one class from the hybrid JD and many, many more.
Yeah.
All right. Well, thank you for that. So we're going to shift gears here into the realm of the legal political world. Fair warning for any one of you who is like, I don't want to talk politics or listen to politics. We may get into a little bit of politics here. I think we're going to get into a lot with these questions. So, Jackie, help a guy out here, or help us all out here. So, I don't know if you heard or read in the news, the Supreme Court just made several incredible precedent-breaking decisions over the last couple of months. I have a couple of questions for you, especially given your background, of course, in the law. How did we get here? How did the court get here? And what's the way forward from your perspective?
Good question. So how did we get here? Well, when we're thinking about the Dobbs decision, or really when we think of the Warren Court, really the court that came up with Roe v. Wade and some of the other decisions during that 60s and 70s, there has been a concerted effort since that time to really move the court away from what was considered to be an activist or liberal approach to constitutional decision making to what was considered to be a more conservative, and I use small c, not a political conservative, but a small c, originalist or textualist approach to it. The judicial philosophy difference between a living, breathing constitution that actually needs to be interpreted to adjust to a changing society versus a constitution that should be interpreted based on the text and kind of the original understanding. So it's a judicial philosophy difference. It was a very strategic and very long-term plan to start to shift the court towards that more originalist and textualist view. And part of it really started in law schools as well. It was decided, the Federalist Society actually started with an attempt to start to influence legal education and to influence new lawyers and their thinking about how to approach constitutional interpretation. The Federalist Society has obviously grown incredibly strong and powerful over the last 30 to 50 years, and it has an enormous influence not just around judicial philosophy, but actually around nominations to the court itself. It has been suggested that on the Democrat side, there hasn't been an understanding about the importance of the court in voting. So when there was a potential for a opening, it didn't seem to drive voters to the polls in the same way that some would argue it drove Republicans to the polls. So it wasn't done overnight. It was a long and strategic march to get us here.
Yeah, I think I've heard some really great analysis that for those thinking that for example, the pro-life movement just popped its head out and said, we've got 3 new justices who are pro-life, for example, or pro-life focused. That's far from the fact. I mean, my mom was a major activist in the abortion rights movement in the late 60s, early 70s. And as she said, from the moment Roe was decided, the strategy shifted. This isn't painting one group or another with, ill intent. It's just saying the strategy was built many, many decades ago and culminated in that decision with Dobbs, right? Is that fair to say, or am I overreaching in that analysis?
That's absolutely fair to say. I think one of the things that people don't realize is that Roe was a paper right for a lot of women in many states because the movement, the so-called pro-life movement, had whittled away slowly and surely at those rights through challenging the existence of healthcare facilities that provided abortions or other types of things that weren't a direct attack on abortion, but made it so that access to abortion was essentially eliminated or made unavailable for many women in the United States.
We've also got this very complex approach to how we understand the decisions that get made. In fact, Phil, who you met earlier, our wonderful producer, who many of you who are listening do not know, but he is the magic behind all of this. We were talking about the weekend warrior legal analyst, and I count myself among them, right? I think I understand and get it. So I'm reading all this analysis. I read the Dobbs decision as an example, and boy, I think I got it right out of the gate, and I understand it clearly. And then I find out I really don't know as much as I think I know, right? So it's kind of recognizing that. But I think a lot of folks across the country, feel like they have a good grasp of these decisions. How do we, and this comes down to legal education, especially, I think, and maybe in a more informal way, how do we work within that framework of helping Americans, everyday Americans, understand the intensity of these decisions, the import of these decisions, and also how to make sense of these decisions? And I'll give you a good maybe not a good example, but an example of like where I thought I got it and then I didn't. So Dobbs, Justice Alito, had really pulled in all this history into the decision. And, from the outside looking in, you're saying, oh, okay, so he's grounding this in very strong historical precedent. I think he went all the way back to 1363. Be that as it may, okay, well researched, depending on if you're on the dissenting side or the assenting side. And then you have the gun rights case, or I believe it was a New York concealed carry discussion or decision. And in that case, they were basically saying that history is not necessarily relevant. Now, I may be, I'm likely oversimplifying that statement. And where I thought I got it, then I'm like, well, wait, is history important or is it not? And how are the justices accountable to these types of things? And so I found myself swimming in a sea of confusion. I know I don't know that there's a question in there other than to say, so we've got all these weekend warriors, myself included, who are trying to make sense of all this. How do you do it? Maybe that's the question. How do you really get to the rub without all the news analysis that's out there?
It really is a challenge. So I could give you a really practical way to do it. There's a blog called SCOTUS blog, and they usually have a plain English approach to any case that the Supreme Court is going to hear, as well as competing views about it from scholars. So it's a great resource. I often send students to it if they're trying to unpack kind of the nuances of a case. But you're right, it's very hard to read a case in isolation because it's built upon a number of previous decisions. And often the dissents of the past are the majorities of the future. So much of what Alito wrote and what Thomas wrote in his concurrence, they had set the stage for in dissents or concurrences in the past. So that Alito decision was not the first time he had voiced those statements in an opinion. And so people who were aware of where we were building towards knew of those opinions and were well versed in kind of where he was going. I think one of the places where you're right, the Supreme Court appears to be getting off track is inconsistency. Even those who kind of believe in the conservative approach to interpretation of the Constitution have raised questions about this majority court's reasoning in multiple cases this term being inconsistent, that it's been hard to find a conservative judicial philosophy thread that easily winds its way through all of their opinions, rather than perhaps a what some people might say a legal realist thread, which is, I'm going to reach the outcome I want to reach. So one of the things that you have to recognize anytime you're reading a judicial opinion is they're trying to persuade you. They're writing persuasively so that you got to the end of the opinion and you thought, well, yeah, that makes some sense. That means that Alito is not bad at writing persuasively. The court has no legitimacy. They're unelected. They don't have an army to enforce their opinions. What their entire legitimacy rests on, and this is why it was so controversial to overturn Roe v. Wade, is kind of that consistency and that kind of keeping their finger on the pulse of where we are in the United States. More than one person on each side of kind of the judicial philosophy spectrum has raised questions about whether or not this court has lost its way and overreached.
Interesting. Well, and again, I'm coming at this from very much a layperson's point of view, but Scalia always struck me as someone, I didn't necessarily agree with him most of the time, but I could follow the through line in the decision making, or not decision making, but the persuasive arguments he was putting together over the long stretch of his career. Mm-hmm. And I think where I was flummoxed in these decisions was just, you hit it really well. And I think that's what's been bothering me, is that it's the inconsistency of the applied reasoning or logic behind the arguments. And I guess I don't mean to impugn the court here, but I would hold I hold our Supreme Court justices to a higher standard, as I do faculty. Right? Like, if you're going to be talking in this fashion, writing in this fashion, you have an obligation.
Well, I think one of the things that we rest on is this idea of ordered liberty, and if we're never sure where our rights stand because there's not a consistent through line. If 9 unelected individuals can suddenly, or 5, quite honestly, take away something, there needs to be an underlying basis for it that doesn't disrupt our understanding of ordered liberty.
That's very, very interesting and fascinating. So, what is an American to do? Like, this court isn't changing anytime soon. If you disagree with it, if you agree with it, you're happy with probably happy with the results. But in terms of what we do for ordered liberty for the sake of constitutional principles, from your perspective as an attorney, and I guess, and I think about it, there are a lot of starry-eyed attorneys out, or soon-to-be attorneys, who are like, hey, I want to make change in the world. And you see kind of the rug being pulled out from the judicial framework that we've been built on for some. What are your thoughts around that? What are your recommendations about how to move forward in this respect?
Well, I think there's a couple of things. One is, and it's a really interesting dynamic that's occurred at the federal level,
Okay.
which is we've become overly reliant on the Supreme Court. The answer to a lot of kind of political disagreements is we'll go to the court and have the court decide it.
Okay.
Congress, which is really supposed to be the most powerful branch because it represents the people, has become paralyzed and rather weak. And as a result, at the federal level, we're very unbalanced. And many of the things that the Supreme Court has done this term can actually be addressed through congressional action. Now, certainly constitutional rights can't be restored, but remember the Constitution sets the floor, not the ceiling. So Congress could certainly act in ways, and we've seen attempts for Congress to act on reproductive freedom, contraception, marriage equality, many of the things that appear to be at risk after Dobbs. The other piece is that local and state level. So perfect example, Montana, a red state, one would expect to have a ban on abortion rather quickly after the Dobbs decision. But 50 years ago, when Roe v. Wade was first decided, the League of Women Voters managed to get an amendment in a constitution that protected the right to privacy. That stopped the Montana legislature in its tracks in attempting to actually enact a ban. So we have to think about it through a systemic lens. It's not just about the Supreme Court, and it's not just about the Constitution. What actions can be taken at the state level, state constitutional level, state legislative level, and what can we implore Congress to do? And so I think there's actually more levers to be pulled than a simple reliance on the Supreme Court as the be-all and end-all of decisions about how we operate in this world.
So in a way, Alito and company have given us a license to do more at the local level. I mean, in some ways. Is that fair to say or no?
They have basically said states get to decide this. We're sending it back to the electorate. So the problem is, and this is why you have to have a systemic view, many of the states are incredibly gerrymandered. So it is challenging when there is a general belief that certain things should exist at the state level, but so many seats are safe that it's difficult for those majority voices to have their voices heard. It's interesting. I think Kansas, I know by the time this airs, Kansas has their constitutional amendment regarding abortion on the ballot right now, and I believe the pro-choice portion was winning, at least at the time last time I looked, and that is a statewide vote versus voting for an individual that you hope might eventually vote on a statute. So constitutional amendments at the state level is enormously powerful.
So regardless of our politics, activism locally and at the state level is key. There's many levers at the federal level. I think you've instilled some hope regardless of what side of the aisle we fall on to, the law has some power to it, has a lot of power to it.
Yeah.
Well, Dr. Gardina, I have two final closing questions. See, that was actually I learned so much in that like 12 minutes, and I could have talked to you for like 3 hours. I think I'm ready for my JD, to study with you. So two questions, and think of these as rapid fire, quick thought as we go through. So the first question I have for you is, what does the term humanistic mean to you?
Treating others as I would want to be treated.
And how does that show up in your profession?
In my profession or in my life?
Both. Either way.
I really do try to treat people with respect and dignity because that's how I'd like to be treated. I tend to think of myself as a pebble in a pond. I have to recognize kind of the ripple effect of my actions, like far beyond me. So I really try to be conscious of that. I think in my profession, unfortunately, lawyers don't have a good reputation at times, and especially in today's world, when we're seeing what's happening with January 6th and some of the attorneys that were involved in unfortunate parts of that incident. But lawyers at their best are about protecting the most vulnerable in our society. And attorneys at their best are about safeguarding the rule of law for everybody. So that's what I try to instill in students, is that really higher obligation that we have that go well beyond an individual client.
That's fabulous. So appreciate your insight there on the humanistic definition from an attorney's perspective, from a legal educator's perspective. That's terrific. All right. You're going to close us out. So with all the challenges we've got, with all the crazy stuff going on in our world today, Dr. Gardina, what are 3 things people can do right now to make the world a better place to live in?
So I know for me, volunteering at the local level brings me great joy. I often feel better when I walk out of my volunteer opportunities than I did going in. I think random acts of kindness are incredibly powerful. I love being able to bring a smile to someone's face. That was unexpected. And right now, I'd say vote.
The 3 things you can do: volunteer, get out there and be kind, and get out there and vote. Dr. Gardina, thank you so much. This was such a pleasure to have you on here today.
Well, Dr. Long, I enjoyed speaking to you, and I'd love to come back.
Oh, we're going to have you back. Make no mistake about that. All righty. Thank you, Jackie. We'll see you.
You bet.
So, I'm dead serious. I think I want to enroll in that JD program. My days are full, but I could listen to Jackie and probably could listen to her colleagues who are teaching those JD classes all day long and really engage in some fabulous discourse with them. It just was so inspiring to hear her speak to all of those topics that we went through today. We packed in a lot over 45 minutes. I hope you enjoyed Dr. Gardina as much as I did. Thank you, Jackie, for your time. Remember her 3 major takeaways: volunteer to get out there and make the world a better place, engage in random acts of kindness, and get out there and vote. If you want to see the video elements from today's episode, we've created these segments. Please visit our Saybrook YouTube page. If you'd like to support the podcast, go to Apple iTunes and leave a 5-star rating and review, and subscribe so you can get episodes as they come out weekly. And if you're on Spotify, leave that 5-star rating and make sure to follow us. You can, of course, subscribe to us on most major podcast platforms, including Google Podcasts, Stitcher, Pandora, and my favorite, Pocket Casts. And guess what I just read in the news today? TikTok has a platform. I don't know if it includes podcasts, so should be interesting. Remember to check our show notes for information on today's guests, including links to websites, books, etc. And for more about our fabulous colleges of law, go to the website at www.collegesoflaw.edu. Click on Areas of Study, and you can find your program of choice there, or simply Google Colleges of Law, Santa Barbara, or Ventura. Thanks so much, everybody. I hope you enjoyed this episode as much as I did, and I hope you'll take care and be well.